Welcome to Legal Talk, the talk show brought to you by the firm of O'Donnell, Weiss & Mattei, with offices in the borough of Pottstown and the borough of Phoenixville. We can be reached at our general office number of 610-323-2800, and you can visit us on the web at owmlaw.com. I'm Joseph Koury, a business and estate planning lawyer, and today with me is my colleague, Rebecca Hobbs, also an estate planning attorney. We are here to talk to you about beyond the simple will and your necessary estate planning documents. Thank you, Becky, for joining me.
Thank you.
We'll broadly be speaking about two different situations. One I will call lifetime planning, and the second for after you have deceased. So why don't we start with the lifetime planning documents?
Sure. So generally when we talk about lifetime documents and planning for your life, there are two main documents that everyone should have once you've turned 18, regardless of your health condition. Everyone needs these two documents, and that is a healthcare power of attorney, which also will encompass a living will or advance directive, as well as a financial power of attorney. And those are your two key lifetime documents. And when we talk about lifetime, what that means is that they're effective during your life, where there are other documents, which we'll talk about later, that are effective upon you passing away.
I think that's an important distinction to be made, Becky, is a lot of times people come to me and they say, well, we have powers of attorney, so we're good for when we're gone, right? And I say, well, that's actually not the case.
Right.
A power of attorney is, again, a lifetime document because upon your death, they cease to be of effect of any kind.
Correct, correct. And I think it's also important to differentiate, the name of the document, you can kind of get an idea of what power that is going to give your agent. But your healthcare power of attorney specifically relates to healthcare decisions. And that document is what we call a springing document, which in Pennsylvania, as long as you are competent to make your own healthcare decisions, then the doctors and healthcare providers are going to look to you to direct your own healthcare. And it's only in the event that you cannot speak for yourself or you don't understand that your healthcare agent then can step in for you on your behalf and make those decisions for you.
You raise an interesting point. You used the word competent when you were talking about healthcare powers, and that they only become effective or spring into effect when you are incompetent, or better stated, incapacitated. Can you tell us a little bit about what could possibly happen if you don't have these types of documents in place and you do become incapacitated?
Right. So definitely when we're talking about the power of attorney, if you don't have a power of attorney prepared, a healthcare power of attorney as well as the financial power of attorney, it may be necessary to have a guardianship proceeding done, that requires going to court, presenting a formal petition, and having a formal hearing in front of a judge, which can be very intimidating for some people. And a guardianship proceeding and action is much more limiting because a court is appointing somebody to be your guardian, opposed to you, when you still have the ability to, deciding who you would want to be that person and stand in your shoes for you. And that can be very important for the healthcare because it's such a personal decision, as well as with regard to the finances.
Well, when I tell people good planning avoids the possibility of a guardianship hearing, I always say those things take two things that you don't necessarily have: time and money. And most people can understand that very well.
Right.
Let's talk a little more about the healthcare power of attorney itself. It's actually got a couple different components. There is one part that does not require springing forth upon incapacity, and that's the first part, if you want to talk about that.
So there is a portion of the healthcare power of attorney that's very important, and that is the HIPAA authorization, which a lot of us are familiar with that HIPAA authorization. Anytime you go to a new doctor, usually you're presented with their privacy policy, which you sign and acknowledge, and then you can explain to them who you would want your medical records to be released to. And so the HIPAA authorization on the healthcare power of attorney is effective generally immediately upon signing the document. And you can appoint agents who would be the person that can step in And they would also be the individuals that could access your medical records in the event they would need them or you would need to access them and have difficulty doing so. And the second portion of the document, which we touched on a little bit, is the living will portion. So the healthcare power of attorney is springing, and then the living will portion, that deals specifically with decisions regarding end-stage medical conditions, where you can put your wishes as far as treatment that you would want to have happen or you would not want to have happen, such as ventilators and tube feedings and things to that nature.
And as you said earlier, if you have a healthcare power of attorney, and in my experience, most people are familiar with the term living will, and they think it refers to the whole healthcare power
Right.
itself. But good planning, if you have a healthcare power with a living will, you're giving guidance as to what treatment you would or would not want in that end stage scenario.
Right, and I have found that it really helps take the burden off the family in the event that you would be in a situation where your living will becomes applicable. It really gives your family peace of mind to know that this was a decision you made and they're not making on your behalf. And that can cause a lot of stress for a family when you don't have that living will and haven't communicated those wishes in writing.
Getting back to the first part, the HIPAA authorization, I just wanted to make the point, and I think you did so effectively already, but I always use the anecdote when I'm meeting with husbands and wives that even though you're married, you're not allowed access to each other's medical records without an authorization,
Correct.
such as that authorization in the healthcare power.
Right.
And occasionally I'll get spouses that'll look at each other squirrely-eyed, so to speak, because they didn't realize that, but that is in fact the case.
Right, correct.
Let's talk a little bit about the other power of attorney, variously called a financial power of attorney, a general power of attorney. No matter what the name, can you tell us a little bit about what this document relates to?
Definitely. So the financial power of attorney is exactly what it says. It's a financial document. So it's relating specifically to appointing an agent, somebody that can step into your shoes and handle your money in the event that you're not able to do so. And it's a very important document, and there are various provisions that you can place in the power of attorney. So it should be tailored to fit your own needs as far as there's provisions you can put in the document regarding gifting, provisions about changing beneficiaries. But the document is very necessary, especially with people living longer with the medical advances that have taken place in our country, as well as the ongoing rise of dementia diseases such as Alzheimer's. And so appointing somebody and having that control of saying who you want to handle your finances is very, very important. And in the same example that you gave with the spouses, a lot of spouses think, well, we're married, so I can have access to those things. And where a problem often arises is with retirement money. In the event that you would need to withdraw from a spouse's retirement fund to pay for his care or to take, her required minimum distribution for that year, then that power of attorney document is going to be imperative.
So when you're meeting with clients, and I think you said it can be a tailored document, the financial power of attorney, talk a little bit about your process in meeting with clients. Is it, slam, bam, thank you, ma'am, so to speak? This is the document that I think you should sign. And also, if you could talk a little bit about who are good agents, so to speak, to be appointed. Yeah,
so whenever I'm meeting with a client, the first starting point to any kind of conversation is looking into the family dynamics. Are you married? Do you have children? How old are your children? Are you close to your children? And then looking at the financial landscape as far as, what kind of investments do they have? What kind of assets do they own? And then making sure that the financial power of attorney is tailored to fit their needs. So no, it's definitely not a one-size-fits-all. Based on the conversation, then I'll make recommendations on what their power of attorney should look like. And then at that point, they'll decide on what they want to have in that document.
And in fact, there was a recent change in the law with regard to financial powers of attorney, if I'm not mistaken.
There was. So as of January 1st of 2015, all of the new law related to power of attorneys became effective. And so it's important to make sure that that document is tailored to fit your needs, because they have these various powers they refer to as hot powers that we often utilize in our documents, but they should be drafted with caution.
So I think I know the answer to this question, but would you recommend or is it advisable that clients can just pull a document off the internet, perhaps?
I would highly recommend against it. Documents online are not going to be tailored to fit your individual needs, and especially with the change of law in Pennsylvania related to power of attorney documents, there are very specific requirements regarding the execution of the document, as far as how many witnesses need to be present and who notarizes the document. And so it's important that when you have a document prepared, that you know it's going to work for you when you need it. And that's why it's important to have an attorney look over your document, make sure that it was executed properly and that it fits your needs.
Before we go to the commercial break, could you talk a little bit about the concept of durability, the durable power of attorney?
Right. So when you hear the term durable, what that means is that the document lasts past the point of incapacity. So it means that if you no longer are competent or have capacity to handle your affairs, that the document is still going to stand, which is important because that's when you need the document the most, is when you're not able to handle that. And so, it's important to have a durable financial power of attorney that's going to be there and be effective when you need the document.
I guess the other side of the coin, compared to a healthcare power of attorney, in your experience, most financial powers of attorney take effect immediately upon signing. They don't require that certification of incapacity, if you will.
Correct. Yeah, most financial power of attorneys are drafted to be effective immediately, opposed to springing into action. And that's an important part of the document, because oftentimes when you need to access somebody's funds, to go through the procedure of having to have somebody declared incapacitated or to have doctors certify to their inability to handle affairs can be burdensome for a family. And so it's important to have that document effective immediately, but to appoint individuals that you trust to handle your affairs in that situation.
Thank you, Becky. This is Legal Talk, brought to you by the law firm of O'Donnell, Weiss & Mattei. We'll be right back after the break.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. Convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Welcome back to Legal Talk, the talk show brought to you by the firm of O'Donnell, Weiss & Mattei. With offices in the borough of Pottstown and Phoenixville, we can be reached at 610-323-2800 or on the web at owmlaw.com. I'm Joseph Koury, and with me is my colleague Rebecca Hobbs. Becky, one last point on powers of attorney. Once you have them in place, are they set in stone forever?
No, you can certainly revoke the power of attorney, and many people will choose to do so, whether you update the document to name somebody different, or whether you decide to a law changes and you need to update the document to be compliant with the new law. So in Pennsylvania, it's important to know that you can revoke a power of attorney, and the revocation just needs to be in writing. Another important aspect of revoking a power of attorney is to make sure that whoever you handed that document to, for example, if you gave it to your bank or if you gave the healthcare power of attorney to a doctor, that you make sure that you let them know that document has been revoked and you provide them with the new document.
You know, I often tell clients that all estate planning documents, including powers of attorney and wills, are what I call walking documents, meaning as things change throughout your life, you need to be aware of what is in your documents.
Right.
For instance, you may name a successor or a backup agent that goes before you, predeceases you, and in that case, you would want to update your document, if not
Correct.
revoke, and redo it wholesale.
Correct.
One last point. We talked about the change in law relative to the financial powers of attorney, and some of our viewers may have older powers of attorney, and it's sort of related to revocation, but if you could talk about the effect of the new law
Sure.
on those older existing powers of attorney.
Right. So if your document was executed prior to January 1st, 2015, prior to the enactment of the new law, then it's grandfathered in. So your document is still good and you don't have to change the document. That being said, it always is good to have your attorney review the document just to make sure that it's still going to work for you. Sometimes it's advisable to update that document even though you don't need to, because financial institutions get used to seeing a document look a certain way, and with this change they now look a lot different than they used to, so it may be advisable to have a new document prepared.
Thank you. So we've talked about powers of attorney, and we've described how they are lifetime documents that really cease to be of any effect upon your death. Let's talk now about wills.
Sure.
And certainly our viewers have heard the term will. Some people may say last will and testament. We're really talking about the same thing here.
Right. Right.
Tell me a little bit about what a will does and what happens if you don't have a will, for instance.
Sure. So a will, like you explained, is an estate planning document that many people are familiar with. So a will is your last wishes regarding what you want to have happen with your assets that you own, and what we refer to as your probate assets. So your last will and testament controls any of the assets that are titled in your sole name that do not have beneficiary designations. So there's non-probate assets such as life insurance that you might name a child or a spouse as the beneficiary of, and those assets pass outside of your will, opposed to your last will and testament controlling those assets that are in solely your name. And so I think that's an important distinction to make for people, because there's a lot of misunderstanding as far as what assets your will actually control.
Sure. Well, what if you have, and it's hard to imagine, but what if all of your assets were non-probate assets? Life insurance, retirement accounts, and the like,
Right.
Where you've named a specific person to be your beneficiary. But then that beneficiary goes before you, predeceases you. What would happen in a circumstance such as that?
So in the event that you have non-probate assets, but the beneficiary, there is no living beneficiary at the time you pass away, then those assets will pay into your estate and pass according to your will. And that's why for every client that I see, I make sure that they understand the importance of having a will, because even though you may have all non-probate assets right now, maybe you're married and everything is titled jointly with a spouse, or you have each other named as your beneficiary, there's always a potential that there may be an asset that doesn't have a beneficiary listed or a living beneficiary at that time, and you need a will to direct who you want that asset to pass to and what you want to have happen with those assets.
What if you don't have a will and all of your beneficiary designations and the like are not effective because of prior deaths and the like? In that circumstance, does the state get your estate?
Yeah, well, that's a common misconception. So if you pass away in the state of Pennsylvania without a last will and testament, I tell my clients, Pennsylvania writes a will for you. So they have law that explains what happens in the event that you pass away without a will, and we call that the intestate succession. And it's a complicated diagram at some points, depending on what your family makeup is. But in the event you would pass away and you're married, and you and your spouse have children together, then what happens is your spouse is entitled to a certain amount right off the top from your estate. It's $30,000, And then the rest of the estate, one half would go to your spouse and the other half to your children. And that can be very different than what your intentions would be. So most married couples want their estate to pass to their spouse. And the other situation that may arise also is in the event that you have children from a previous marriage. In that situation, the estate would go one half to your spouse and the other half to your children. So you can see the importance of making sure you have a will to direct what you want to have happen with your estate.
Now, tell me, who makes sure, and assuming you do have a will, who makes sure that those assets get to whom you want them to get to?
Right. So you appoint an executor in your will, and the executor has the big job of administering your wishes and carrying out your intentions with the document. And so your executor is the one responsible for probating your will, which is the process of going to the Register of Wills in the county that you passed away, in the county that you had property and resided at, and then administering that document and making sure that the assets get distributed according to the will.
And it sounds like, and I think you said the executor has a big job. It sounds like an executor, the choice of executor should also be evaluated carefully, just as your agent under the power of attorney.
Right, correct. And whenever I am counseling with clients on how to choose who the executor would be, I had one client who felt very strongly that each child should have a job. And so they wanted to name, one child as the power of attorney for the finances and a different child for the power of attorney. They didn't want anyone to feel left out. But it's important to know that when you're picking an agent, when you're picking an executor, you want to pick somebody that's going to be right for the job, and not necessarily making sure that everyone feels included, but to make sure that you're picking the right person that can fulfill your wishes when it comes to the job that you're giving them.
And can you name just one executor?
You can certainly name more than one. You can name co-executors. I would recommend against, if you have 6 children like my parents do, that you not name all 6 children as co-executors, because that can be a little confusing when it comes to coordinating everybody getting together to sign documents. But certainly you can have co-executors, and often people do decide to go that route and appoint more than one person as an executor.
And isn't it true that just like if you die without a will, your property may pass in a manner that you didn't want? If you don't have a will, there may be a person whom ideally you wouldn't want administering your estate.
Right. So the law, just like the law dictates kind of who gets your assets in the event you don't have a will, the same thing happens with the executor. And the law explains, who has the right to step in and serve as the administrator in the event that you haven't chosen in a document. And so it's important to make sure that you have your will and that you've thought it through, and you make sure that you appoint an executor that can carry out your wishes.
It sounds like good planning, again, is the order of the day. Let's talk a little bit about what if a person has children, young children, that they want to name in a will as receiving property.
Right.
And at the time that the will is drafted, they are, in fact, young, under the age of 18, for instance.
Right. So this is where it comes back into that conversation where we're talking about one size doesn't fit all. You need to have an estate plan that is tailored to your specific situation. So where a young couple has children that are under the age of 18, there are a couple important things that you need to think about. We never want to think about what would happen in the event that we're gone and we have to choose somebody to take care of our children. But that's something really important to do. And so to think through, who you would want to appoint as the guardian of your children in the event that you weren't there to take care of them. And that's something that your will should address. The other piece of that is also, if you have children under the age of 18 that would stand to inherit your estate, should you not provide for example, a minor's trust in your will, then depending on the amount of money that your children are inheriting from your will, you will be going to court, or your executor will be going to court to have a guardian appointed for them to handle their assets until they turn 18. And so in that situation, it's really important to have what we call a minor's trust to hold the assets on behalf of the minor. That way they have access to those monies for things such as health, education, and maintenance. But then you designate a specific time that they would inherit the money outright. And it can be at 18 or it could be at 25. And you can choose an age that you think they would be responsible enough to inherit the money.
Yeah, most of the clients that I draft wills for with children, when I mention, are you comfortable with them inheriting as soon as they turn 18, the answer is no.
Right.
And in that case, as you alluded to, you can essentially structure a trust that they don't get it all, so to speak, until a certain age, whatever the parents say.
Right.
And then, of course, you need to name a trustee in that situation.
Correct, yes. And the trustee would be the individual that would, invest the money and make distributions from that money on behalf of your child.
So to recap, I think in terms of what we call fiduciaries, I heard executor, I heard trustee, I heard guardian, perhaps. Some very important people in your life.
Right, right. Yeah, those are, really important decisions too. And it may be that you choose the same person for all of the roles, or you choose different people, because each of those roles kind of have a different job. And so it's important to think through those decisions carefully.
Great. Well, I think we're just about out of time with our program this evening. We've talked about powers of attorney as being lifetime documents, planning for incapacity, and avoiding the time and expense of going to court. That was also a theme that you echoed with regard to wills and children possibly inheriting, wills being documents that provide for the disposition of your assets once you're gone.
Correct.
Thank you for joining us for Legal Talk, the talk show brought to you by the law firm of O'Donnell, Weiss & Mattei.